certainly thank you to Rachel and Mike and Dean Mazza and my fellow panelists. It's been a good afternoon so far, and I trust that it's been valuable for all of you who are listening. That said, I have to confess that as a judge, it does feel a little bit dangerous to walk into a room full of lawyers who have been primed by an entire afternoon of thinking about judicial misconduct. So I will do my best to be on good behavior. So as I confronted this topic, I did what I often do, which is whenever I am confronted with a problem, the first question I always ask myself is why? So here, why judicial ethics? What purpose is even a conference like this actually serving? And the most common rationale given for the existence of judicial codes is that they're necessary, in the words of, I'll quote the preamble to the Kansas Code of Judicial Conduct, that these codes are necessary to maintain and enhance confidence in the legal system and to ensure the greatest possible public confidence in our judges' independence, impartiality, integrity, and competence. And this is no doubt true, because we know that a corrupt, a wicked, or an incompetent judiciary is one of the surest paths to a lawless society. Now, that being said, it does seem to me, or at least it seemed at the outset of thinking about this, that given that this is the stated purpose of judicial codes, ethic codes, there's something big missing from our narrow understanding of judicial ethics as represented by our codes of conduct. Indeed, a realistic assessment of the public's confidence in judges and their judgments really does suggest that the quality of judicial decision-making itself is the primary factor affecting that public confidence in both courts and in our rule of law. I think that really one needs only look so far as, for example, President Biden's commission on the future of the Supreme Court, or the editorial pages of the New York Times, or dare I say, law professor Twitter, to understand that the ethical contours of judicial decision-making is the most pressing judicial ethics question that we face today. And yet, judicial decision-making is routinely excluded from this field of judicial ethics. Now, I think, and it's probably indisputably the case, that the reason it's excluded is largely because judicial decision-making is not amenable to judicial discipline. So oftentimes when we think of something like ethics, it's paired directly with discipline. So one of the premises of at least my talk is the idea that I think is widely accepted, that ethics, and here the ethics of judging, extends beyond behaviors that are subject to discipline. So it is to an ethic of decision-making that I want to turn my attention in this lecture, because judicial decision-making is itself quite fraught with ethical complexities, paradoxes, uncertain boundaries. And here I offer a quick caveat that I know many of my fellow panelists have also said, which is simply that this subject is larger and more ambitious than can be tackled here in my short time today. So perhaps consider this to be a teaser, a preview of what I hope to address at greater length in the written work that will come out of the symposium. Mike and Rachel, at least that's my plug for the Law Review Symposium's edition. Everyone get out there next spring and buy it when it comes out. To begin with, turning back to the topic, I think we need a clear understanding of the judiciary's self-proclaimed ethical imperative for judicial decision-making. Justice Stephen Breyer, in a recent interview with the Washington Post, responded to criticisms of his court, including criticisms of his more conservative colleagues, and he did so by invoking the institutionally accepted ethical standard of decision-making. This is what he said. The single most important point is judges are not junior league politicians. They're judges. Maybe the political process worked to get them appointed, But once appointed, the judge will believe that the jurisprudence, that judge will believe that the law really requires the result. In what I think of as essentially identical fashion at the National Lawyers Convention of the Federalist Society last week, I saw it reported that the speaker kicking the convention off, who was Sixth Circuit Judge Amul Thapar, was introduced to the audience as a judge who, quote, follows the law wherever it leads, even if that means throwing nuns in jail. I think that was intended as a joke and was probably a reference to one of his decisions, but certainly embedded in that is the central ethical imperative that an ethical judge in the course of decision-making will follow the law wherever it leads. And those are just two examples among many that represent what I'll call the official piety of the judiciary when it comes to talking about what we do, what judges do. And this is true across the entire spectrum of judges and courts. Good ethical judges follow the law wherever it leads. Whatever the result may be, good judges believe in their heart of hearts that the law really requires that result. It would only be an unethical judge who would do otherwise. Therefore, it is often said, and sometimes it is often implied and sometimes said, that any criticism of judges as politicians in robes or as usurpers of the law is certainly misplaced and wrong. Now, I have to pause here and insist that you not misunderstand me. In my view, this official piety has a great deal of truth to it. It has much to recommend it. But at the same time, it is a bit more complicated than that, isn't it? I think mature, common sense people of all stripes really know this intuitively. I do find it interesting, however, how uncomfortable it often makes us to admit as much. And given that, I think we judges are sometimes reflexively defensive when it comes to these complexities. Because court after court after court will routinely reduce the ethics of judicial decision-making to this simple binary choice. Either a judge is following the law wherever it leads, or the judge is engaged in results-oriented judging that supplants the law with the judge's own preferences. And by way of example, I'll pick ever so slightly on my own court, and here are just a smattering of pronouncements on the matter from the Kansas Supreme Court. From a case called In Re, the Adoption of XJA in 2007, quote, an appellate court should refrain from rewriting a plainly worded statute to simply reach a desired result. Result-oriented justice is directly contrary to the concept of the rule of law. From Leeming versus USD number 214, this is in 1988. Result-oriented justice is government of men and not of law. More recently from State v. Thomas in 2018, quote, working backwards, that is starting with a desired premise and then manipulating legal doctrine to justify that preconceived result is the very definition of result-oriented jurisprudence. And I could go on, but I'll stop there. The most important takeaway, I think, and I hope this will become more clear in a moment, is that each of these pronouncements came in a written dissent. And to be fair, I too have engaged in this sort of tisk-tisking when we write separate opinions. And so my example comes from the case of State v. Gleason in 2017, where I write and quote as well my good friend and colleague, Justice Carol Beyer, the majority leaves the impression that it starts with what it views as a palatable result and works backward to articulate a rationale. So what is really going on here? Do we judges just take turns, depending on the decision, violating our prime directive to follow the law wherever it leads? And I think we know that the answer to this is no. Something else is actually going on. And it's that something else that I think is worth exploring from within an explicitly ethical frame. At least that's the task that I've set for myself here with this lecture and paper. So let's begin with a deeper consideration of the ethical imperative to follow the law wherever it leads. And that imperative springs directly from a core character of the law itself. Here I'll quote Stanley Fish, who has observed that, quote, "The law wishes to have a formal existence. That means, first of all, that the law does not wish to be absorbed by or declared subordinate to some other non-legal structure of concern. The law wishes, in a word, to be distinct, not something else, and in its distinctness to be perspicuous. That is, it desires that the components of its autonomous existence be self-declaring and not be in need of piecing out by some supplementary discourse." This kind of formalism is in fact imprinted on the very DNA of the Western legal tradition. Formalism claims, again, in the words of Fish, that the law can be written, quote, "with such precision and simplicity that its meaning leaps off the page in a way that no one, no matter what his or her situation or point of view, can ignore." And this legal clarity is supplemented by procedures that are self-executing, in the sense that their unfolding is independent of the differences between the agents, that is, the judges, who might set them in motion. Thus, we can say with confidence that judicial willfulness is stopped short and obliged to press its claims within constraints that it cannot override. Another author, Hans Kelsen, put it this way, perhaps with greater purity: "The law is an order. Therefore, all legal problems must be set and solved as order problems. In this way, legal theory becomes an exact structural analysis of positive law." And here's the money quote: "free of all ethical, political value judgments." So to be more colloquial about this, I think it's the story of judges who are concerned exclusively with a procedural result, let's say fairness, for example. But these judges give little to no thought to the substantive outcome or the result of their decision when they apply the law to a particular case. That outcome or result is already baked into what we might call the rule of law cake. In this telling, judges are like master bakers. We meticulously follow a complex but knowable and intelligible recipe. And at the end of the day, hey, don't blame us if you don't like the cake. Blame the recipe, right? That's the formalist procedural account of the ethics of decision-making. And the fact that it appears to solve what we might call the problem of law's indeterminacy is what really gives it its rhetorical power and its lasting and seemingly unbreakable grip on the judicial imagination. Because indeterminacy in the law and the interpretive difficulties that come with it is, of course, a very real problem. And it's a problem that the formalist account claims to be able to solve. Indeed, it's true. The danger of subjective decision-making, which is predicated on little more than the personal whims or biases of a judge, is a clear and imminent danger. As I wrote recently in the case In Re FC just this year, as I tried to articulate this danger, quote, the reality of subjective judicial decisions driven by the biases of judges is a perennial problem, because that bias is nearly always exercised on behalf of the upwardly mobile, middle-class, bourgeois, and polite society from which the majority of judges come, and in which most judges continue to live. When judges are forced to choose between competing values, there will be a systemic bias in favor of the values of the upper middle professional class from which most lawyers and judges are drawn. So that's the danger, which is a very real danger, which the formalist account is designed to prevent. But of course, it has one glaring flaw. For as every judge, lawyer, and frankly, person with ordinary common sense will understand, the recipe is not as clear or complete as the formalist myth would suggest. Sometimes, in fact, grandma's notes are vague, right? Any of us who have ever made grandma's cookies probably understand this, because really, How much is a pinch of salt? Sometimes the instructions are crossed through. They may be interlineated in confusing and uncertain ways. Other times, entire sections of the recipe are simply left out. And in such circumstances, it does not seem especially comforting, or dare I say ethical, to tell people who are dissatisfied with the substantive outcome to just, quote, blame the recipe. While we can all likely agree that it is wrong for a judge to simply change the recipe based on the fact that that judge likes, let's say, chocolate cake better than carrot cake, it is unsatisfying to suggest that no master baker has an ethical responsibility for the substantive quality of the cake. In that sense, it's oddly counterintuitive, I would suggest, to say that a judge should not care one whit about the result. And further, to say that if he or she does care, that that is somehow unethical. Well, those are vexing problems, at least from the perspective of a sitting judge. They're jurisprudential problems, no doubt, and that's how they are most often discussed. But at least for our purposes and my purposes today, I think that it's important to acknowledge that, at least for the conscientious judge, and most of us are conscientious judges, these problems also have an ethical dimension. Now, it would be foolish, of course, for me to suggest any kind of easy or pat solution to this enduring and potentially unsolvable problem, but my ambition does at least extend to making an attempt to provide a helpful contour to understand the problem. And to do so, I am going to turn now to an unexpected source, the wisdom of an ancient book of Jewish law, the Babylonian Talmud, known as the Bava Metzia. And a quick side note about pronunciation: with many of these names, there's a good chance my pronunciation will be imperfect. I will do my best, but I would also be happy to be corrected by any of you who may know better. That said, the Bava Metzia is a legal tract. It mostly deals with areas of commercial law, property ownership, credit law, and the like. But it does contain one of the most fascinating and deeply perceptive fables of judging that I have ever encountered. And I want to share it with you. I think it's instructive. At the outset, it is important to give credit where it is due, and I need to note that I'm deeply indebted for this portion of the lecture to Professor Daniel Greenwood, who has done brilliant and fascinating work on the Bava Metzia and its relevance to the Western legal tradition. So my account and telling of these stories is derivative of Professor Greenwood's work, and I'll use his words interspersed with my own as I try to tell this story in a way that makes sense. This fable, which is now known as the Oven of Akhnai, is the account of one particular legal decision and its aftermath. And the fable's chief character is Rabbi Eliezer, who is acknowledged throughout as the preeminent rabbi and scholar of the law of his generation. Rabbi Eliezer is depicted as a man with a brilliant mind, a man with deep virtue, and a passionate heart. He is the unquestioned authority within the council of rabbis. So, in the ordinary course of things, a legal dispute was brought before this council, which would sit as a court of final decision. Now, the question concerned a clay oven and whether the food that had been cooked in this oven was ceremonially clean or unclean. The oven, this Oven of Akhnai, had been broken and then repaired. And the law provided two possible rules to resolve the case. There was the rule of broken things, and there was the rule of repaired things. And the outcome of the dispute depended entirely on which rule the court would choose to apply. Thus, the case really does present the kind of dispute that lawyers and judges are quite familiar with. It's simply a choice between two rules, though, of course, the substance will feel unfamiliar to us. So continuing with the story, as the arguments are presented, the court of rabbis is divided. A majority of the rabbis take one side of the question, while the eminent Rabbi Eliezer takes the other. Rabbi Eliezer contends with all the learning, brilliance, and authority that he can muster. It is, in fact, recorded that he, quote, made all the arguments in the world, and yet still the court was unmoved. And it's here really that the story gets interesting, for Rabbi Eleazar's dissent takes a form that we mortal judges can only dream about. For he summons the very power of God in his defense. First, he offers miraculous signs to the council. If I am right, he declares, let this carob tree prove it. And the carob tree flies 100, or some say 400 cubits through the air. Again, Eleazar shouts, if I'm right, let the rivers prove it. And indeed, the rivers flow backwards. But the story continues, the council of the rabbis is unmoved. As a side note, I would say that's not unlike some majorities that I have encountered. This majority says, we cannot accept the legal rulings of trees and rivers. Rabbi Eleazar has one last move to play. This is his real trump card. And so he turns to the court and says, if it is as I claim, heaven itself will testify. And behold, the bat kol, which is the heavenly voice, went forth and said, why are you disputing with Rabbi Eleazar? For it is as he claims everywhere. Now, as Professor Greenwood slyly remarks, in a world of sovereign-centered positivism and formalism, surely this would end the matter. The founding father has told us exactly what he meant. Any difficulties of interpretation have been authoritatively taken off the table. All that's left for the rabbis to do here is to be good ethical decision makers. That is to say, to follow the law wherever it leads. But they don't. In fact, Rabbi Joshua, who is the leader of the majority, stands up and declares this: Torah is not in heaven. Torah was given at Sinai, and since that time we do not pay any attention to the bat kol, for it is already written, the law must incline to the majority. And the account continues that as of that day, they brought all objects that Rabbi Eleazar had declared pure, and they burned them in the fire, and voted to excommunicate him from the council because he had the audacity to invoke the bat kol and thus destabilize the law. Now, the first chapter of this fable concludes with one magnificent detail. Later, another rabbi, Rabbi Natan, who had been at the council, meets with Elijah, who is often an intercessory figure between heaven and earth. And Rabbi Natan asks Elijah, what did the Holy One, that is God, do when the council rejected the bat kol? And Elijah replies, God merely smiled. And he said, my children have defeated me. My children have defeated me. Thus, this first chapter of the story encapsulates the whole paradox of text, intent, and interpretation. For it turns out, Eleazar was right all along. And yet heaven still smiled, for Torah is not in heaven. It is instead in the majority of the rabbis, even when the majority is wrong. But the story doesn't end there. The second chapter, if it was a Hollywood movie, would be titled Rabbi Eleazar Strikes Back. For he retains all of his formidable powers, and now he's really ticked. Heaven, it seems, continues to favor Eleazar, for he uses his miraculous authority to exact revenge on all those who cast him out. First, the story notes that the rabbis were fearful of even telling Eleazar the result of the court's decision because they knew that he might, quote, destroy the whole world in his anger. They were fortunate, it seems, for we're told that Eleazar only destroyed 1/3 of the olive crop, 1/3 of the wheat crop, and 1/3 of the barley crop. Additionally, the fable continues that on that great day, everything at which Rabbi Eleazar looked was burned up. Apparently, Marvel superheroes did not invent the Superman laser eyes. Rabbi Eleazar got there first. Not long thereafter, another of the presiding rabbis who was in the majority happened to be shipwrecked, and it was said that it was, quote, on account of none other than Rabbi Eleazar. The final chapter of this story, the fable of Akhnai, concerns Rabbi Eleazar's death. Things have not gone so well for his students after his banishment, for while heaven had smiled on their judgment, it came at the cost of losing their father, teacher, and friend. Several of his students attended his deathbed, though, of course, they meticulously remained separated by the distance demanded by the legal ban. Still, there is some reconciliation achieved, and at his passing, the other rabbis cry out, "Woe unto me, my master, because of thee. Woe unto me, my teacher, because of you. For you have left the whole generation fatherless." And then we are given one last scene. Rabbi Eliezer now sits among the firmament after his death, discussing what else? The Torah, with none other than Moses and the Holy One, as Rabbi Eliezer instructs them on the finer points of the law. So who in the end gets the last laugh here? Who was ultimately vindicated? We want to know. Framing it in the terms of this talk, who was the ethical decision maker? The Bava Metzia denies us the satisfaction of an answer to these questions. For the fable of Akhnai is filled with paradox and misdirection. And that, of course, is the point. For while this is a fable about many things, it is principally about the paradoxes of decision making. In the end, the Oven of Akhnai is a powerful exercise in myth making. And here, in the interest of time, I will conclude these remarks with the words of Professor Greenwood. Quote, "Akhnai shows both the attraction and the importance of the traditional answer, both excluding it in favor of the current majority and condemning the majority for that exclusion. The very authorization of majority rule reminds us that the majority is not authorized to do wrong. The very act by which the majority asserts its right to rule is simultaneously accepted as an act of the majority and criticized as wrong. Even a majority entitled to make the rules is not entitled to dishonor and exclude its minority members. Law is a communal experience," Greenwood continues, "without a fixed or predictable result. Akhnai stands for the power of paradox over coherence, wisdom over logic. Akhnai is a part of a battle to define the limits of civilized discourse. Invocation of absolute truth is incompatible with continued debate. Akhnai chooses discussion over truth, living together over correctness. And yet, Eliezer, like the tradition for which he stands, remains attractive and important, even if he must be excluded. For in rejecting him, the rabbis deny Eliezer and the truth, the respect that he and it rightly demand, thus contradicting the principle that entitles them to exclude him. In so doing, they have left an entire generation without its teacher and father." And finally, my words now, the fable of Akhnai opens up for us the terrifying reality that for a court, a judge, and even for a political community that is in the throes of an especially difficult decision, heaven smiles mischievously down at us. For indeed, the Torah is not in heaven. Thank you.